Hello, I'm Ishan Mehta, a solicitor here at Clark Hemning Lawyers. As a lawyer who specializes in construction law, I know how frustrating and costly delays in construction projects can be. We get clients almost daily that have or are being affected by delays that put financial and emotional strain on them. We also regularly see clients that have been issued with variations which often are for thousands of dollars and which can blow out the budget of a build well beyond what they expected or sometimes what they can afford. Today, I want to let you know about some of the common causes of delays in building projects and what you should consider in relation to them. So, what are some of the common causes of delays in construction projects? Could be labor shortages, material shortages, design changes, unforeseen site conditions, force majeure events like pandemics or wars. Depending on the nature and extent of the delay and the terms of your building contract, there are some important matters that you need to be aware of. So what are these? Extension of time. This is generally a provision in building contracts that allows a builder to extend the completion date of the build, often without penalty or liability, if the delay is caused by factors beyond its control or that are the result of actions on part of the owner. As an owner, you can make sure that your actions do not cause such delays by ensuring that when you engage with the builder, you do so in a timely manner. There may be other reasons that allow you extension of time, such as delays in materials, access to site issues, or a delay in being able to get trades. This is particularly an issue at the moment for builds in country areas. These are all matters you should look at carefully and get legal advice on before signing your contract, as they can have the effect of allowing the builder to extend the date they finish your build by many months, and maybe matters that in part you don't agree with and therefore need to negotiate on before signing your contract. Of course, there are other reasons that are in the builder's control and for which you must be compensated. As a buyer, you must make sure that this is covered in your contract with the builder. Damages. These can be liquidated or actual damages. This is a contractual provision that requires the contractor to pay a predetermined amount or actual amount of money to the owner for each day of delay in completing the project, as compensation for the owner's losses. Many contracts do not contain a provision that provides for such compensation, and this is a matter you should get advice on before signing your contract. This is because extensive delays can put you in financial distress, especially if you are paying a mortgage as well as rent whilst your build is being undertaken. Termination. This allows either party to terminate the contract if the delay is so severe that it frustrates the purpose of the contract or makes it impossible to perform. Contract will have a provision that outlines the circumstances in which you or the builder can terminate the contract. There are often clauses that contain other matters that you must comply with before terminating a contract. If you're thinking about terminating your contract, it is really important that you get legal advice before doing so, to ensure that you can and that any required procedure is followed. If you get this wrong, it can be a very expensive mistake for you and could land you in court. Litigation. This is the last resort, as the legal costs can be substantial, the process isn't quick, and it can be stressful. There may also be alternative dispute processes under the terms of your contract that you need to follow, so it's important that you get advice about this. Building can be one of the most exciting times for many, but it can also be stressful and result in disputes. It is important that before signing your contract, you understand the risk to you financially and in respect of time if things go pear-shaped. If you have been given a contract, we recommend that you get it checked by a lawyer to both negotiate amendments and to understand it and what may occur if things don't go quite to plan. One of our experienced building and construction lawyers here at Clark Hemning Lawyers can assist you with this. It is important for you as a buyer that your contract covers you for such delays and ensures that you get compensated for them. It also puts positive pressure on the builder to take action swiftly and complete the build in the committed time. When it comes to variations, the contract must ensure that any changes to the price of the build are limited to an agreed percentage. Lately, builders have used rise and fall clauses in the contract. Rise and fall clauses allow the price of a fixed price or lump sum construction contract to increase or potentially decrease in accordance with fluctuations in supply prices and wage growth for specific materials and labor. The potential issue with such clauses is that the contract does not remain a fixed price contract and the buyer could end up paying much more than what they signed up for. We highly recommend a review of the building contract to look at delays and variations clauses, along with a number of risk factors that may affect the building of your dream home. If you're about to sign a contract, reach out to us. Our team here at Clark Hemning Lawyers has years of experience in the construction and building industry. If the contract is already on foot, we can review it and guide you on the best possible legal remedies that may be available to you.